appeal in the matter of Shanghai Shipyard for Limited and Reignwood International Investment Group Company Limited.
Yes, Mr. Bailey.
My lord, I appear for the appellant, my learned friends Ms O'Sullivan and Mr Wright, for the respondents over there. And may I dive straight in, as it were, by showing your lordship, or reminding your lordship of the essential contractual documents and the facts that form the background to the point of law of construction of the guarantee in this case. And might I start by just briefly showing the shipbuilding contract, which is in the supplementary bundle, tab 1, starting at page 3. But if I can go straight to page 5 of the bundle, which calls itself page 1 of 67 of the contract. And it's dated the 21st of September 2011, and it is between Reignwood International Investment Group Company Limited of Hong Kong at an address in Science Museum Road in Kowloon on the one part, and Shanghai Shipyard Company Limited, my client, of the Republic of China on the other part. And perhaps I can just draw your attention at page 31.
31 in electronic?
31 in the bundle. These are the numbers at the bottom right.
So, just so we don't have to ask you every time, is that internal 27 of the documents?
No, I will, as a default proposition, refer to the page numbers of the hard copy page bundles, unless I indicate otherwise. I had hoped that would be the same as the PDF.
Uniquely, this is the first case. I've done hundreds with electronic bundles where the electronic bundles coincide. So, Mr. Berry, you're there, you're standing up, you are to be congratulated.
Because they do coincide.
Because they do coincide.
That's your cue to thank the people behind you, Mr. Berry.
I believe there is an app for that, but I'm not personally...
I have been saying for weeks, months, years, for goodness sake, it cannot be beyond the wit of man for the numbers to coincide electronically and on paper.
The app that I've seen even manages to do that, where there are inserts called point ones. And that is very clever.
That is good.
But
Let's see if it's still doing it at the end, Mr. Berry.
I've tempted fate rather too much, but I am... Page 30.
Keep going.
Page 31 then. And what is part of 8.1c in the middle of the page? The final instalment payable upon delivery of the drill ship, and that's what it provides for. I should tell you that that was amended by addendum number 3. The reference is core bundle, page 78, but I won't take it to you. That was amended so that the final instalment is payable not upon delivery, but upon physical handover. And the words physical handover therefore replace delivery in the title to C and in the last 3 lines also of C. The payment method, if you look over the page at 32, in what is clause 8.2b, the final instalment payable on delivery, not apparently amended in paragraph in addendum 3, but there is provision there that one often sees for an advance, an irrevocable cash deposit of the final instalment before delivery. That's the payment substructure, if I can put it that way, within the contract. And then at page 33, clause 8.6, there is provision in the shipbuilding contract for security for payment of instalments before delivery, requiring an irrevocable and unconditional letter of guarantee, the payment guarantee, in the form annexed here to as Schedule 6B. Just to then, there are many terms in here that could be said to be peripherally relevant, but I think that's all I want to show until we get to Schedule 6B, which is at page 71. And that is the blank form of irrevocable payment guarantee. And if I may then go to tab 2, page 79 of the bundle. This is this is also on the basis of a standard form in the contract, which I didn't show you, but which was Schedule 6A. But at page 79, it's what's called an irrevocable completion guarantee. My learned friend makes a point on it, so we should just note that in effect it is a refund guarantee for the refund of the first and second installments in the aggregate of $30 million US. The price was 200 million, so there were refunds, there were advance payments, if you like, of $30 million. And I won't read the terms out, but I think at page 80, we see that clause, in the event of any dispute between you and the builder in relation to liability to repay, if I summarize, and such dispute is submitted for arbitration in accordance with Clause 17, we shall be entitled to withhold and defer payment until the arbitration award is published. And that is has a parallel in the refund guarantee, sorry, in the payment guarantee, which is at page 83. Now, if I may, I will come back to the detailed terms of this, the important instrument on which my client sues. But for present purposes, can I just note various features about it? It's dated 17th of November 2011, so it postdates the shipbuilding contract. It is to my client, the Shanghai Shipyard, which is the builder under the shipbuilding contract. And it is issued by Reignwood International Investment Group Limited, which is the buyer, described as the buyer, the owner. But also, we, Reignwood International Investment Group Limited, grant the guarantee. So the guarantor at the time of the guarantee was identical to the owner, I call it the buyer under the shipbuilding contract, which may be a matter of importance. And also, I don't think it's controversial, but it's an international instrument in respect to international trade, in that the Shanghai Shipyard is in Shanghai and Reignwood is a Hong Kong company. It appears to have Singapore managers, but I don't think that makes any material difference. Now, may I then move to the core bundle for the basic factual matrix, I submit, of the contract, the guarantee, the demand, but also the litigation, which obviously postdates the contractual documents, but show a course of events that in my submission would have been entirely foreseeable at the time. And that is core bundle, tab 5, starting at page 47. And the first three entries at the bottom of page 47 are for the contract, the completion guarantee, and the payment guarantee, which I've briefly identified.
Is this an agreed chronology? Because not all the entries have references.
I understand it's an agreed chronology, yes. And 48, we see that on the 30th of November 2012, so a year later than the contract, there was a novation by which Opus Tiger 1 replaced the guarantor as owner under the contract. And then there are dates for delivery, and the third and fourth entries have been reversed. So what actually happened is that on the 10th of December 16, the guarantor petitioned to wind up Opus Offshore, which was OTI's immediate parent for debts.
The 10th of December, you said.
Yes. I think this is English dating, not American dating.
So I don't understand what you're saying. Are you saying this date is wrong in here?
No, the dates are right, but the date order has been reversed. The chronology is normally
I see, 12 and 20.
linear, but 12 comes after 10.
Yeah. but the events are correctly stated.
Well, I
It's just
think so. Yes.
So the notice of completion was the 12th of December, and the guarantor was the 20th. The petition was on the 20th.
Yes. That's
Okay.
my understanding, although it's couldn't be checked from the bundle, and if I'm wrong, may I have a locus penitentiae? And then there's a notice of completion of the drill ship, and then on the 11th of January, there is a demand notice by the yard to OT1 requiring the payment of the final instalment. And then on the 23rd, that actually not having been paid, as we know, the notice of default is sent. 17th of February, OOL, that's the intermediate company and the parent of OT1, wound up by that court order. And can I interject there to show you a document that is not in the bundle, but relates to this December period, and that is a witness statement of Mr. Cheng in the supplementary bundle, tab 5, page 94. In the Bermudan court, in the context of those proceedings.
And again, just to be clear, these affirmations and witness statements, we've got an affidavit in the supplementary bundle. These were before the judge and treated as evidence in the preliminary issues, were they?
As I understand it, yes. Mr. Sullivan was there. That's my understanding on the basis on which they're in the bundle.
There's no objection, my lords. I can't honestly recall whether this particular affidavit was before the judge.
But we can proceed on the basis that the evidence is
I can check.
evidence that we can rely on.
Yes, but I can check the position, but yes.
Thank you.
And so this is dated, as we can see from page 107, it's the 22nd of December 2016. And for my purposes, paragraph 23 at page 102, so page 102, paragraph 23. Mr. Cheng is Vice President, or was then Vice President of Reignwood, and providing context at paragraph 23, or background, he refers to the setting up of the company, the Opus management team. And then in the fourth line, he says the Opus management team introduced to Reignwood an investment opportunity in the deep sea offshore oil drilling industry. Reignwood agreed to participate as a financial investor in the Opus group of companies to invest in 4 Tiger drill ships, each of which would be held by a single-purpose vehicle. And I will submit that that's some context if the nature or involvement of the guarantor is material. Then
Does that mean that although it took a while for Opus Tiger 1 to be introduced as the novated buyer, it was at all stages contemplated that would be the framework, and therefore it would be a 3-party situation, although for a period it was a 2-party situation?
That is a reasonable inference that was an event in the contemplation of the parties, my lord, yes. On that, I will submit, however, that when construing the guarantee, it has to be construed against the possibility of novation and no novation, because the shipbuilding contract itself does not require or even explicitly provide for a novation.
So it has to be construed against the background of...
Might be, might not be a novation.
Might be novation. Possible novation. Yes.
then at page 103, and this is material, my submission to the context of the demand, at page 103.28. Each Tiger drill ship is being built by Shanghai Shipyard. Contract value is 200 million. The first instalments of the 4 is 30 million, making a total of 120 million, which was funded by Reignwood, as the Opus Group did not have any funds at all. And then 29, presently only the Tiger 1 drill ship has been built. Now that is the material ship for our guarantee in our contract. Although the title has been transferred, the outstanding sum of 186 million due to Shanghai has not been paid, and consequently Tiger 1 drill ship is still berthed at the shipyard and has been mortgaged to Shanghai Shipyard. As I understand it, Tiger 1 drill ship was delivered without payment of the balance contract value. And my submission on that is that at this time there appears to have been no dispute about the due, because that 186 million can be worked out. It is inclusive of the 170 million, and then there are variation orders and things of that nature. So at that time, at least there is evidence of no dispute, and I would put it the other way, no evidence of a dispute over the accrual of, or the dueness of the final instalment, if that be relevant. I should then, I won't read the rest of the affidavit, although there is material, but should identify for you the next affidavit in the bundle, which is at tab 7, page 111, and that is dated the 6th of December 2018. When we go back to the chronology, we'll see that that's rather later on. And by this time, the same Mr. Cheng, in the Singapore proceedings, the essence of which was to be permitted to, I say colloquially, take over OT1 and arbitrate in their name. By that time, there was a dispute, and that can be seen briefly, if I may put it this way, at page 133, paragraph 53 and 54, where they say there were defects. Now, if I may then go back to core bundle, page 48, and run through the rest of the contextual chronology, we have, I think I got to 17th of February 2017, I should have done, but February 2017, the cancellation notice was sent by the yard to OT1, and then on the 23rd of May 17 was the demand by my client to the guarantor on the guarantee. The demand itself is not in this bundle, it was in evidence, but it's pleaded and admitted. The points of claim are paragraphs 19 and 20 at the core bundle, page 73. And the demand is admitted as a document, of course, at defence paragraph 36, which is core bundle, page 96. And there is no issue that if my client is otherwise right, that the demand was a sufficient demand under the guarantee. Going back to page 48 then, my client issued proceedings and over a year later, on the 29th of August, it obtained permission to serve the claim form in this action, seeking to enforce the guarantee. And it took a while. On the 5th of October, the guarantor acknowledged, on the 2nd of November 18, and the guarantor acknowledged, indicating the intention to defend. Particulars of claim on the 7th of November, they are at tab 10, page 69 and following, but I don't think I need to show you anything particular in them. And then, after particulars of claim, on the 10th of December 18, the guarantor commenced proceedings and commenced providing is a spelling mistake for commence proceedings. In Singapore, seeking leave to commence that arbitration. There was a defence in those proceedings. If I may interject in that chronology, on the 8th of January 19, the defence in the English proceedings was served. That's C tab 11, page 81. And then there is reference to various affidavits. But over the page at 49, if I can skip straight to the second and third entries, on the 6th of May 2019, the Singapore order granted the guarantor leave to commence the derivative action, and on the 3rd of June 2019, the guarantor commenced the arbitration, and then there are references to these proceedings, by which I mean the preliminary issues, the pleadings and the preliminary issues. So the preliminary issue was ordered, and if we look at the judgment of...
Sorry to interrupt you. What's happened to the arbitration proceedings?
May I interject at this point? I have the advantage of hearing that arbitration, unlike my learned friend. It took place between the 21st and the 29th of June, between a tribunal of three, in front of a tribunal of three arbitrators. The chair was Julia Dias QC, and the co-arbitrators were Nicholas Strauss QC and Claire Blanchard QC. So that took place quite recently, and we are awaiting the award.
Thank you.
Thank you.
And whilst I've interrupted you, what's happened to the vessel?
Again, my lord, it is in the shipyard in Chongming Island.
Thank you again. So the judgment of Mr. Justice Robin Knowles in tab 7, can I just identify at the moment, page 56, the preliminary issues? They are in paragraph 10 at that page 56. And they were heard on the 4th of December. And the judge gave judgment on the 4th of December in these terms, which I'll come back to. And that led to the order at tab 6, page 50 of the bundle. 3rd April 2020. And at page 50, there's a recital of the preliminary issues going through to page 51, and then the declarations and order against which we appeal. In respect to preliminary issue A, the guarantee is a see-to-it guarantee or conditional obligation subject to 2 below. Liability thereunder arose only if the Part 20 defendant, which is OT1, was liable. And then in respect to preliminary issue B, the defendant is entitled to refuse payment pending and subject to the arbitration. And then there was permission to appeal of the judge. Now, looking at these preliminary issues, in my submission, the question raised by preliminary issue A, disposed of by order and declaration number 1, is in essence whether the guarantor is liable only if the owner, buyer, is truly liable for the final instalment. And the essence of that is that that describes a contract of suretyship, also known as a see-to-it guarantee, or whether, as we contend, the guarantee contains an obligation to pay against documents which are a demand has to be in writing, or possibly a demand plus other documents. But for preliminary issue 1, it is a demand guarantee and not a contract of surety or see to it, so long as its nature is pay against documents, even if there is in truth no underlying liability.
A demand saying what?
Saying what it has to say, but in this case the final instalment has not been paid. In other words, the wording of the first part of clause 4 of the guarantee, which I probably haven't paraphrased exactly accurately in that answer. So I will paraphrase it accurately. The owner has failed to punctually pay the final instalment. Now, it is still and that dichotomy has been rightly characterized in Paget for a number of editions now, as approved in the Wuhan case in the Court of Appeal, as being contract of surety versus demand guarantee. And for the purpose of preliminary issue 1, it is a demand guarantee whether the document it pays against is simply the demand, or whether the document it pays against is an arbitration award. Either way, it is an instrument on the demand guarantee side of the dichotomy, because that which triggers payment is the document and not the underlying truth of liability. If I am right about that on issue number 1, and the judge decided issue number 1 against my client, then issue number 2 arises, which is on the assumption it is a demand guarantee in the sense identified. Then what are the documents, or what are the conditions against which it pays? My learned friend appropriately describes it as a conditional payment obligation. So the question then is, well then, what are the conditions? And my submission on that is that the condition is only a demand unless by the time of that demand there exists dispute between owner and builder and it has been submitted to arbitration. But in those eventualities, and only in those eventualities at the date of demand, then this is a demand bond which pays against an arbitration award. So those are my submissions in a nutshell. And on preliminary issue 1 and preliminary issue 2, and I should simply say now, so as to get it out of the way now, if we are right on both, then there's no other defence to the claim on the guarantee, and I would be inviting the court not only to make declarations, but to order the money be paid. Now, may I then go to the wording of the guarantee? I will follow that by making some submissions about the authorities on construction of this sort of instrument, and indeed in my submission, constructions of materially indistinguishable instruments. And then after looking at the authorities, if I may, I'll just come back briefly to the wording of the guarantee.
It's all a bit odd on timing, isn't it? Because you're going to have an arbitration award in a discernible period. And if you win, you're going to say that we ought to order the payment of whatever it is, 170 million. Then what happens if the arbitration award is half that?
Well, then...
back in guarantee territory.
If and when an appeal process is gone through, which may take...
I thought there weren't
There's no
many
right of appeal
appeals.
under the arbitration.
No, exactly.
There's no right of appeal, but it's an LMAA arbitration.
It's excluded. Clause 17 excludes an appeal, doesn't it?
You may be right.
So, I mean, this may be all a complete waste of time.
But it may not be if there's liability under the. If there are a number of possibilities in which
Well,
it's
I
not a waste of
understand there are a
time.
number of possibilities, Mr. Berry.
But you're not a party to the arbitration.
I'm not.
So
Sorry. I am.
I'm-
My learned friend is not, except
Sorry.
that she is with another hat.
sorry, yes.
Yeah. But curiously, I'm personally not. Yeah. But there are a number of possibilities in which the guarantee pays, but the arbitration award might not. One theoretical possibility is that the final instalment is not due as a debt, but that the buyer has repudiated the obligation to take delivery and is liable for the amount of the final instalment in damages in which case the effect of liability under the guarantee would be practically to secure that damages liability.
But that would have to give credit for the value of the vessel, that
It would.
damages claim. So it won't be in the amount of the final instalment.
It wouldn't, but my client would then have security and the cash flow advantage of the final instalment.
What's the juridical basis for your client's obligation to repay if they've recovered in full on the guarantee?
It is Cargill in Bangladesh. It is an implied term in the shipbuilding contract that we repay the owner, which of course may or may not be for the benefit of the creditors. But this discussion just raises the point that if my client is right here, then that is not likely to be academic for all sorts of reasons as to the destination of the money. And that is why I would invite your lordships not to consider any sort of adjournment of this hearing or adjournment of judgment in this
I
hearing.
haven't heard an application for adjournment.
Because it is not, or not necessarily academic.
But the arbitration award is not binding, subject to your point on clause 4, as between you and the guarantor in determination of the liabilities in the underlying contract.
Correct.
So it would be open to you to say, whatever the arbitration says, we don't accept that result, and therefore we don't have to pay it back.
We don't have to pay it back to the guarantor, but I would have to investigate whether we would have to pay any excess back to the buyer under the Cargill principle.
Right.
But I think the upshot is that because that would arise in the arbitration, there would be an issue estoppel preventing my client, because the obligation to reimburse, I think it's an obligation to account for any excess received under the guarantee to the buyer. That would be subject to the arbitration between the parties to the arbitration, and it would not there be open to my client to reopen.
And in the circumstances of this case, where the buyer's been wound up, or in any event appears to be insolvent, that may not be something which is of any value to the parent.
To the parent, quite. But that is the way, that is the way English law deals with the situation where a demand guarantee is called and the beneficiary receives more than it is truly entitled under the underlying contract. And the way that is dealt with is duty to account to the contracting party in the underlying contract. The obligations under the guarantee have been correctly paid, and the guarantee action is over, and the guarantee is, as it were, then a matter of history.
I'm not familiar with Cargill and Bangladesh. It seems to me, by facie, slightly surprising that the obligation isn't to account to the paying party, but I'll have to have a look at that.
I'm afraid I'm sort of breaking through my memory of these issues. I have dealt with them in the past, but my recollection is not what you say, so you'll perhaps need to show us Cargill.
Or possibly a textbook.
There is a little bit of discussion of this in the Van der Merwe case, which is in the bundle. Of the position happens, the right of the surety to recover any overpayment, and how that would work as a matter of mechanism, which might be.
Do you happen to know where that discussion is in Van der Merwe?
It's not a very long decision. Yes, I'll tell you shortly. It's number 2 in the authorities bundle.
Yeah.
And it begins really from paragraph 22 onwards, and this is Lord Justice Waller.
Deals with the last point first.
Because one of the arguments there that this couldn't be a demand guarantee because the sureties would have no right to recoup the payment. That's why they considered it.
I should say that I'll try and check up the Cargill principle over the short adjournment.
It's referred to, isn't it? Isn't that the case that's referred to, paragraph 23?
Oh, 23.
Cargill and Bangladesh, is that the one?
Yeah. There's
Yes.
Justice approving, Lord Justice Potter approving Mr. Justice Morrison.
I should say this, that there is, in my submission, and maybe that establishes it sufficiently, an obligation to account for an excess, an obligation on the party in the position of my client to account for an excess collection under the guarantee to the other party to the shipbuilding contract.
I mean, the problem is insolvency here, isn't it? It seems to me, at first sight, that we're dealing with a quite complex insolvency issue, which is the interaction of the law of insolvency with this principle we're now looking at. If it were solvent, then there would be corresponding rights between the buyer and the guarantor, which may not work in an insolvency context, because if the buyer is massively insolvent and all sorts of other creditors who are going to take the bulk of the repayment that you make, this is I have no idea what the answer is, but it's obviously very, very fact dependent.
But in my submission, whatever the answer is, it lies outside
the scope of this
action, this appeal. And so the consequence of a decision in this action, this appeal,
we have no discretion.
Are to be dealt with elsewhere.
Yeah, we have no discretion, because we think that there may be an injustice perpetrated if you're right as to the law.
Well, I would submit that you shouldn't think there's an injustice perpetrated, because Reignwood is the company that owned the insolvent subsidiary and is guaranteed in terms that it guaranteed. Where's the injustice? If I'm right, sorry.
Just a couple of points of fact here. Firstly, OT1, the buyer, is not itself in any form of insolvency.
Okay.
Its parent, the Bermuda company, is insolvent, was wound up on the 17th of February 2017. OT1 is under the control of the joint provisional liquidators of the parent. The other point of fact is that Reignwood is not the 100% owner of the buyer. Reignwood owns 70% of OOL, which is the insolvent intermediary in Bermuda. That insolvent intermediary owns 4 shell companies, OT1 to 4, each of which holds a partly completed drill ship. OT1 is not without assets. I mean, there is some debate as to whether it's solvent or not, but it has some assets. It also has creditors, amongst whom are Reignwood, but also other companies within the group. As I say, so it's not 100% subsidiary. That's an important point.
One would expect it as a special purpose vehicle for the purposes of buying this vessel, not to have substantial assets.
No, its main asset is the part completed drill ship, in effect. It's a slight peculiarity.
To which it curiously, in this case,
Has legal title.
did acquire title.
Yes.
Although it wouldn't normally have done so under the
Yes.
building contract as originally contemplated.
It is technically the owner,
Yes.
but the ship is in the shipyard, and the shipyard has the benefit of a mortgage. And if it's right about the non-payment of the instalment, has rights of sale and so on. So it's a slightly complicated situation.
Yes, thank you.
Anyway.
I'm very grateful for that. I think I can summarise it by saying that in the 4 walls of this action, that's all very interesting, but doesn't arise. And in this action, the simple question is the result of the preliminary issues as between, that are before the court. And the consequence of my being right on the preliminary issues is that there is no defence, and judgment ought to follow whether or not it creates insolvency complications later on. Now,
Well, speaking for myself, I am still interested in the Cargill and Bangladesh point, because it might have some bearing on the second of the preliminary issues.
Yes, and insofar as that is concerned, my submission on that in summary now, and I may have to change it later, is that there is a general duty to account on the beneficiary shipbuilder to the buyer. That's the principle in Cargill. It has not, so far as I know, but I'll have a look, ever been decided that there is any duty to repay under the bond itself. And in my submission, that would logically follow from the fact that it is a demand bond, and therefore the payment was rightly made, even if the buyer was not truly liable. But that question, the obligation, a possible obligation to repay in the event that it's found that the buyer was not liable, was raised but not decided by the judge in this case. As I recall, but haven't got the paragraph to hand. And if there is a duty to repay under this instrument, this would be the first time that had been held.
45, I think. I prefer not to express a view given the limited argument I heard on the question whether and in what circumstances there could be a repayment obligation.
That's right. And in my submission, the repayment obligation issue doesn't arise, but might be pleaded if my client is successful at this hearing, and then it's held in the arbitration that the final instalment wasn't due. But that might be complicated by questions of whether a smaller sum was due by way of damages or of that nature. So to summarise,
Well, that then would be an issue on which you'd be entitled to say, we don't care what the arbitration award says, to claim between guarantor and yard. We can express our own views and litigate again whether there was an underlying liability.
yes, quite, which is perhaps one reason why the law has dealt with it in what I submit is the Cargill way rather than the repayment under the guarantee way. But I do submit, now that I'm standing here think about it, there can't be an obligation to repay under the guarantee, can there, if it's a demand bond payable simply on certain demand. Because what is the basis for repayment? There's no mistake of law. it was due because the demand is all you need. There's no mistake of fact because the fact of actual liability is not part of the condition for payment. And there's no unjust enrichment because of the Cargill duty to account.
I think the contract of guarantee is the contract that is the contract between the guarantor and the principal debtor is the question there.
Yes.
I mean, speaking for myself, it does look to me as if you're right that there isn't any, it can't be a legal claim to repayment on a demand guarantee, but I mean, question whether under the second head there could be some impediment to payment. I mean, this is perhaps for the argument on the second issue. I mean, it's interesting that Mr Justice Knowles says, I don't need to decide it. So we'll probably get to it under the second issue again.
We may, but my submission now is that actually there can't be. If I'm right about the first issue, that carries with this point with it, because it's a demand guarantee that's
Well, except that clause 4 is odd, isn't it?
Clause 4 is odd, but if it's not triggered, then well,
No, I've heard. I know what your submission is. Let's get on.
Let's look at the contract,
Yeah.
if we may. Supplementary bundle, page 83. I've already, in passing, made the points that it's, at least as initially drafted, between Reignwood, who is also the owner as well as the guarantor. I've already made the point that it's an international instrument between a Chinese company and a Hong Kong company, which at that time made a difference. And I then do make the submission that while Reignwood International Investment Group Co. Limited is not as such a bank, we've seen from the context of the affidavit of Mr Cheng that it is a financier who advanced the funds, and so it is in a sort of intermediate position between a banking lender.
Well, I think the expression was investment, which
Yes.
is quite the same as financier in business terms.
It made an investment and it said it funded,
Yes, the first instalments.
yes, by way of loan, which is in the chain. So whether it calls itself an investor or a funder, it has sorry,
It's somewhere between the two.
a financier. It has, yeah,
It's not a bank, but it's not a parent simpliciter.
right, and it has lent the money. I mean, that may be consistent with being a parent, but it is funded instalments and would fund the 170 million by loan to probably the subsidiary, but my learned friend would no doubt be able to explain whether the loan is to the intermediate OOL and then to the OT1. But the point is, it's halfway between a parent and a bank in my submission.
I'm still a bit troubled by the fact that this is a guarantee guaranteeing Reignwood's own liability.
Well,
I know that it was intended that it should change, but guarantees are strictly construed.
quite. And my lord, in my submission, that is a significant factor in favour of it being a demand guarantee, because otherwise it would, on the hypothesis of no novation, confer no additional benefit.
Sorry, I hesitate to interrupt. I am a little concerned that we're venturing here into factual territory, which has never been canvassed before. I mean, certainly there's never been any evidence. As I understand it, this guarantee was entered into because of the contemplated novation, which took place about 13 days later. So if it's being said that it was ever seriously contemplated that Reignwood would guarantee itself and that there wouldn't be a novation, I mean, I think that's something that needs to be made good by the facts. I mean, there's no point in having a guarantee by someone of their own liability. The point is to guarantee somebody else's. So I've always proceeded on the basis it was undisputed that this guarantee was entered into in contemplation of the novation and just happens to predate it by a few days. I mean, if that's now being said to be factually wrong, I am concerned because this is a point that's not been taken previously.
Well, with respect, it wasn't pleaded by my learned friend and hasn't been put in evidence that there was any actual matrix contemplation of a novation. And unless the chronology is wrong, I think my learned friend is not entirely accurate about dates either, because if we look at 47 of the clause, the contract is dated September 11.
Ah, yes.
And if we look at 48 at the top, the novation is dated November 12. But there have been other mistakes in this chronology, but that was my understanding of it. And in my submission, were it to be suggested that there was any positive evidence of factual matrix to be advanced, to the effect that it was contemplated, that would have been for my learned friend to advance in evidence for the preliminary issue, but as I understand it, there is none. However, I do not dispute that inferences can be drawn from what everyone knows about how shipbuilding contracts work, that a novation would have been in the contemplation of the parties, and inferences can be drawn from what happened as to what was contemplated, because what happened in this case is, in my submission, not in any sense out of the ordinary course of a shipbuilding.
And it goes a little bit further, because we've got Mr. Cheng's evidence that when Reignwood was first approached by the three individuals,
it was to fund it.
It was to fund it, and it was contemplated at that stage that there would be incorporated special purpose vehicles to become the buyers.
And my lord has solved the problem, if there was one. But my submission, but as to the contemplation, as to the factual matrix. But my submission still remains that is a contemplation, not an inevitability, and a guarantee, being strictly construed, must be construed against both possibilities. And insofar as, on its face, it guarantees or it provides an obligation relating to the owners in two capacities, that is a pointer. I don't say it's conclusive in any way, a pointer towards it adding something to an underlying truthful liability. The second point to note, so three points. International, between the same party as guarantor and owner, and the third point is that it's called a guarantee, but in my submission that is neutral, because the question as formulated in Paget is whether it's a contract of suretyship or a demand guarantee, and certainly by now the word guarantee has come to be used just as much for a demand instrument as for a contract of suretyship. And then clause 1, moving on from the identification of the parties, are the words irrevocably, absolutely, and unconditionally guarantee in accordance with the terms hereof as the primary obligor and not merely as the surety for due and punctual payment of the first instalment. And we rely heavily on those words. It's sort of piling Pelion on ossa. It's irrevocable, it's absolute, it's unconditional, it's a primary obligor. And these words are important in my submission, and not merely as the surety. Now, as the issue is rightly described, contract of suretyship versus demand guarantee, and as the concept of suretyship is the concept of see to it and pay or procure that the underlying obligations are performed, words that say this is not only one of those are very important. To take them anything other than literally would be wrong, but saying that it's not merely a surety means that it's more than that. That's clause 1. And if I can go to clause 3 at page 84, the same points arise, but this is about the interest provision. So in my submission, that doesn't take it much further. And clause 4 is the crux of it. and it provides that in the event that the owner fails punctually to pay the final instalment guaranteed here under in accordance with the contract or interest, and such default continues for a period of 15 days, then upon receipt by us of your first written demand, we shall immediately pay to you or your assignee all unpaid final instalment, together with the interest specified. And in my submission, the in the event in this and in many other, I said all similar guarantees, doesn't mean that there must be a true liability to pay the final instalment. It merely means that the final instalment has not been paid in accordance with what the contract says about its payment. And that is there because one can hardly write a guarantee without specifying what it is necessary to demand as to trigger the guarantee. And you'll see that concept many times in the obligations. So the structure here is that there's demand is to assert a failure, a default. The default then has to continue for 15 days, and then there is the right to demand and to payment on demand.
Can I focus for a moment on the amount of the final instalment that can properly be demanded? The shipbuilding contract provides in a typical way that there can be adjustments to the final instalment price, and they can go both ways in this contract, not always. There's a discount for accelerated delivery. So suppose that the discount applied and the final instalment which was due was only $165 million. An effective demand would only be able to demand $165 million, would it?
Yes, because of the doctrine, because of the requirement of honesty in making a demand. But only because of that.
Only because of good faith. So if there were a dispute about
Yes.
whether there'd been a sufficient advancement in the date and a dispute over the amount,
Yes.
then
You obviously, by reason of legal principles, cannot demand more than you know.
it's the good faith principle that limits. Yes.
Which has been, would it be fraud to demand to say 170 million is due when it wasn't, when you know it wasn't? So that would be the fraud exception to the letter of credit type.
Yes.
It's not just the principle of good faith.
Well,
I'm always very careful when.
No, that's what I mean by the.
Good faith,
It's
no fraud.
It's always a requirement of a demand under an on-demand bond, just as it is under a letter of credit, that the demand is made in good faith,
So that
as well as being conforming.
that establishes that principle. And the other way, if it's more than 170 million, as it was in this case, because you saw the 186 million figure mentioned, nevertheless, this guarantee only covers the original 170 million final instalment and doesn't cover modification extras. So that solves the
The other way around.
the other way around, and good faith solves the shortfall. But so the clear structure is final instalment due, or alleged to be due in good faith. 15 days is given unto the builder to pay it, and then after that 15 days, my client can make a demand on this guarantee, and that would be 15 days after the demand on the buyer. And then there's a proviso, and in the event there exists dispute, and the question really in issue 2 is when, and we submit on date of demand. And it's not just any dispute, it's a dispute over liability to pay the final instalment. I say that because it's been decided in arbitration cases that there is a dispute when somebody simply doesn't pay, whether it says that there's a reason for not payment or anything else. But that's a dispute sufficient for the appointment of an arbitrator. But that kind of dispute doesn't work for this clause because it must be a specific type of dispute. And for that purpose, one is looking for the builder saying, no, I'm not liable for the final instalment. And it's never been suggested that the builder said that before the time of demand, or indeed, I think at any time until the guarantor took it over. So in the event there exists a dispute characterized there, and such dispute is submitted, and in my submission, that's the form of the preliminary issue, but in this case, that submission also has to be at the time of demand. Then, by either side, then we shall be entitled to withhold and defer payment until the arbitration award is published. We shall not be obligated to make any payment to you unless the arbitration award orders the owner to pay the final instrument. If it fails to honour the award, we shall pay the extent to the arbitration award orders. Now, the point to note about that is that it is payment against a document, and it is payment against an arbitration award, even if the arbitration award is not final and binding, as one could easily have written. Now, though there is an exclusion of an appeal under Section 69, it is well known that there are many other ways, or other ways of challenging the final and binding nature of an arbitration award. And therefore, the essence of this proviso, if it is engaged, is to pay against a document the award, even though there may still be a dispute about the underlying liability on grounds, for example, that the award is open to challenge under Section 68. They didn't, as is sometimes done, as we'll see, they didn't say final, binding, and unappealable. So the character of the proviso, if engaged, is a demand guarantee, not a contract of surety, because on the condition it is to pay against the document. And posit, if the award comes out but is reversed under Section 68, then what happens? Well, the guarantor will have had to have paid, but the accounting principle may then cut in as between the owner and the yard. Now, at page 85, I would also rely, so we say clause 4 in both its parts are strongly in favour of, indeed I think I put it higher, are conclusive of the nature of the instrument as being a demand guarantee, not a contract of surety. And that's in both parts. And my learned friend submits that the proviso is pointed towards suretyship, but it isn't. It is not a proviso that says we will pay if you're liable. It's a proviso that says we will pay if you get an award, be it final, binding, or otherwise. But we also rely on Clause 7a. Our obligations under this guarantee shall not be affected or prejudiced by any dispute between you as the builder and the owner under the contract, and that I think must be construed to mean the owner at the time of dispute, rather than the owner as described herein. But the judge at paragraph 23 said, well, this doesn't apply to disputes about the final instalment. But what else? What else could it apply to? It's only a dispute relating to the final instalment that could conceivably affect the obligations under the guarantee. In my submission, that is an impossible construction. It means disputes other than about the final guarantee, because of that consideration, and also because of the word any. Now, pause a moment then and remind oneself of the essential difference between a refund, a demand guarantee, and a contract of suretyship. It is that actually disputes about the liability and the underlying contract are the very thing that do affect liability under this guarantee. Because if it was a suretyship, then the dispute between the builder and the buyer would necessarily affect it, because the buyer might be right. So this, together with the words not merely as surety, in my submission directly address the important question, suretyship or demand guarantee. In the one case by saying this is more than a suretyship, and in the other case by saying liability hereunder arises is unaffected by a dispute on the underlying. How much more clearly can you put it on the demand guarantee side by saying unaffected by disputes? Now, my learned friend says, but there's a conflict between that and proviso to number 4. No, there isn't. The proviso to number 4 is an exception to the principle in number 7. It's a specific clause about a specific type of dispute that is that has certain other conditions to it. It has to be a particular type of dispute, and it has to be submitted to arbitration, and it has to have arisen and arbitrated by submit in a particular time. There's no conflict. Proviso to 4 is simply a carve-out of the general principle in 7a. And there is no problem there. And if then we look at 7b to G, one has there the exclusion of a list of defences that can otherwise be raised in contracts of suretyship. And this factor has often in the past been relied on as a pointer towards a contract of suretyship, because 7b to 7g would be appropriate to that type of contract and less appropriate to this type of contract. But in my submission, it is actually a neutral factor, as has been said in some of the authorities, because these provisions are included from an abundance of caution by a process described by Lord Justice Longmore in Wuhan. I think he borrowed the term from somewhere else, as a palimpsest process of piling clauses taken from other contracts on top of each other. And in modern conditions, that exclusion is, in my submission, neutral. And then paragraph 8, I simply identify it's the written demand. So in my submission, that is the demand relating back to the main part of clause 4, and that is the document against which there is to be payment. At page 87, paragraph 10 is of some but possibly limited importance. This clause was mentioned in some of the cases. The maximum amount, I won't read it out, but the maximum amount is the 170 million plus 60 days interest only. And that indicates, or has been said sometimes to indicate, a demand bond, because there is little time for investigation.
I should ask this, wouldn't one expect, it strikes me as odd that there's no reference in clause 4 to clause 7 and vice versa. Or is that perfectly common in this type of contract?
It is perfectly common in 2 of the examples of this type of contract that I will show you in a moment. I hesitate to say that there's any perfect normality in this area. Because what happens, I think, as a matter of notoriety is that these documents are picked up and the transaction people use a precedent and then tinker with it. But there are, I think I'll answer that question by saying there are other examples of exactly that same phenomenon.
The clause 4 proviso is bespoke, as it were. It's not in the CMAC.
It's not in the CMAC, but it is.
One sees some variations of it in other cases.
Yes,
it's not in the standard form on which this wording was based.
Exactly, but it is it is precedented, but not standard. I think is how I'd summarise that.
Without clause 4, would you accept that without clause 4 your case would be even stronger than you say it is? In other words, it's only clause 4 that causes you any conceivable difficulty on the on-demand.
The proviso to clause 4 in my submission is in my favour on the first issue, because it shows the nature of the bond as something, the guarantee as something that pays on a document. Of course, clause 4 proviso is my problem in the second issue, because my learned friend says it is engaged. So the answer to your question, my lord, is yes and no. Yes on issue 1 and no on issue 2. But may I just go back to clause 4 and 84, another point, just because this was picked up by the judge in the multiplex case. The other indicator, if any more was needed in clause 4, is that the obligation is to pay immediately on first written demand. Now, in a contract of suretyship, the guarantor, if it were a true contract of suretyship and in the three-party situation, the guarantor could not reasonably be expected to pay immediately because it would at least have to investigate with the underlying debtor whether it was liable. And this is a point made in multiplex, but it's a very sound one in my submission. The concept of immediately on demand is important. And in this case, it's important on both the first and the second issue.
Well, it's the critical point on the second issue.
It is. It is, because my submission on the second issue, I've made my submission on the first issue. So coming to the second issue, the point is that a liability to pay immediately, 2 points, cannot reasonably be taken away retrospectively by subsequent events. Not least because...
It's either engaged or not engaged.
Yes, and because to plead a defence of subsequent events, the guarantor would be taking advantage of its own breach in not paying immediately. And it's a well-known general principle that contracts are to be construed not to permit that. So 2 points. It's retrospective stripping away of accrued rights, which is a most unlikely proposition. And secondly, it's retrospective stripping away of accrued rights that can only happen by the guarantor taking advantage of its own breach in not paying immediately. Now, the facts of this case, if it's the two-party case and there's no novation, of course there's no problem in the guarantor procuring the later dispute and the later arbitration so as to take advantage of its own breach in not having paid immediately. But in the novation situation, certainly as contemplated, as my Lord Popplewell mentioned from Mr Cheng, what was contemplated was subsidiaries. Even if it be true that there's a 70% subsidiary of a 100% subsidiary of something, the expectation must have been that Reignwood, the original guarantor, would then be the party that could control, either in corporate, well, through the corporate ownership, the owner, and could procure that the owner raised a qualifying dispute and commenced arbitration. The fact of the Bermudan insolvency has meant that in this case the procuring took a little bit longer and cost a little bit more than normal, but the ability of Reignwood to create a dispute, to start an arbitration, whether there is or is not novation, would have been foreseen and foreseeable at the time of the contract and is material to the construction of the proviso on issue 2. So to summarise, not clear enough to take away accrued rights, and a fortiori, not clear enough to take away accrued rights which depend on taking advantage of one's own breach in not paying immediately. So the pay immediately is key, both...
Well, it seems to substitute, the clause in the last two sentences seems to substitute a liability to pay the arbitration award for the liability to pay
the demand
immediately on demand. And I think you would say once you've got a vested right to an accrued right to payment, then it's not drafted in such a way as makes you think that it's substituting that for an accrued right. In other words, it's one or the other, and you say immediately means the one, because there was no dispute within the terms of the proviso at the time, and this proviso is all about disputes that arise at the time, although it's not well drafted because it could easily have said that.
But if it were to take something away...
Well, it would be. What you're saying is, as I understand it, it would be taking something away, which is impermissible.
it's impermissible and would have to be drafted a great deal more clearly than that to take away accrued rights. And as I say, particularly accrued rights which accrue only because you're in breach of the obligation to pay immediately. In other words, unclarity goes against my learned friend, not against my client, when considering the effect on accrued rights. And the facts of this situation, whilst perhaps a little bit, the timescale is a bit more extended than it might sometimes be, these facts are quite, there's nothing here that could not have been foreseen, except possibly the insolvency of the intermediate holding company. And it would be a worthless instrument if the guarantor could say, I'm not paying, and then procure a dispute at any time. It would be commercially worthless.
Well, it's not worthless because you've got a demand guarantee for the award.
Okay, it's not worthless. It would take away what in my submission is half of the worth of such things, at least, if not more, which is the cash flow situation, which of course, in such a situation as contemplated by the guarantee, the yard has spent over 100 million in building the ship.
This is just a timing point. I mean, that is the effect if they start the arbitration in the 15 days before you can make your demand. So
true. But that shows that the right to suspend the cash flow benefit would need, in my submission, to be drafted clearly to take away one of the benefits that is
I think it's
generally
more than
acknowledged.
cash flow. I mean, I think it's more than cash flow. I think guarantees are construed strictly, and they create rights, and they create fairly binary rights, and this is, you say, one. I mean, if it's clear, and it's a clear liability, once that is a liability on which you could notionally sue that very day and get judgment that very day, then how does that suddenly get taken away by the proviso?
And incidentally, my lord would have done, but for the having to go through the hoops of service out, etc., 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 thus giving them time to start the arbitration. But yes, I'm now praying in aid the commercial dire consequences.
I mean, one has to just almost ignore the intervening steps which happened in this case due to the international corporate structure that was actually put in place. I mean, this is a document that appears to be drafted to contemplate short time periods and payments being due at particular times without regard to that corporate structure.
And it works on its own face. And in my submission, I'm sort of almost making reply points here because it's more the judge and my learned friend who say, I will look at the context. One of the contexts they say is it's not a bank. So therefore it's not a banking insurance. So therefore it should be presumed not to be a guarantee. And then, so questions of context are, as we perceive it, predate against us to take away the clear wording. And in this part of the submission, I'm merely saying if one is into dire consequences or uncommercial consequences, then there is that uncommercial consequence of my learned friend's submission, which is it takes away all the cash flow benefit. My Lord Popplewell says, but that would happen if they disputed and arbitrated within the 15 days anyway. Or possibly, as often happens, there's a dispute and arbitration before delivery. That is, I'm not giving evidence here, but it's very common that the dispute arises before delivery because there's a raft of change orders and things of that nature. So there's an ample scope for a dispute and an arbitration before the 15th day after the tendered delivery. And there's nothing in the context in my submission to take away what I submit is the clear wording, but if there is, I say it, the context goes my way as well. May I run through the authorities, if I may? Now, the first thing I say about this is that each instrument, it's repeatedly said that each instrument is to be construed on its own wording without preconception. That is something that is often said. On the other hand, it is said against my client that there's something called the Marubeni presumption, which says that if it's not a bank, then there's a presumption that it's not a demand guarantee. In my submission, that presumption, well, can I take you to that, which is in the authorities bundle, tab 1, and hopefully page 13. Let's see. Well, actually, may I just start at page 6, just to identify the guarantee itself. So page 6 of the bundle, page 2,500. What have we come to? 2,500 of the report, and the guarantee is quoted at the letter G, F to G, and the effective words are just below the letter G. The undersigned Ministry of Finance of Mongolia unconditionally pledges to pay to you on your simple demand all amounts payable, if not paid when the same becomes due. So there's a concept there of becoming due. And then held in this case, it was a contract of suretyship and not a demand guarantee. And the case is cited for the principle, page 13, paragraph 30 of the report, where Lord Justice Carnwath said, turning to the Ministry of Finance letter, the starting point, in my view, is that it is not a banking instrument and is not described, either on its face or in the supporting legal opinion letter, in terms appropriate to a demand bond or something having similar legal effect. The legal opinion describes it as a guarantee, terminology not conclusive, but he agreed with the judge that if the Hong Kong company had wanted additional security of a demand bond, one would have expected them to have insisted on appropriate language to describe it, both in the instrument itself and in the legal opinion. The absence of such language in a transaction outside the banking context creates, in my view, a strong presumption against HK's interpretation. And in my submission, the point about that is the absence of such language. And we have ample language here, which was not there. The language there was pay what's due. Our language is, well, you've seen the language, but it's close.
Is that what's being referred to? Paragraph 30 is talking about the language used to describe the document. And then paragraph 31 looks at the wording of the instrument itself for the purposes of displacing the presumption.
Well, it's not described or in terms appropriate to demand bond or something having significant. But in my, well, your Lordship may be right, but the appropriate language, such language, can be in the instrument itself.
I think that's what it's referring to, actually. I'm not sure it's talking about an external description of the type of document, but maybe I'm wrong.
It may be, that's my submission, but either way, if there is a strong presumption created by the label at the top.
But I mean, this is, you know, the risk of the risk of saying something I shouldn't. I mean, this is loose judicial language because you don't have presumptions about the construction of instruments. They are instruments and they're construed according to the principles of construing instruments, and that's the beginning and the end of it. And it's very inappropriate for this court or any other court to create presumptions about how you construe a particular document. I mean, if you say this language means this, then if later people use that language, they know what it means. That's a different point. This is not what he's saying.
I adopt that submission, but I submit even if there is...
That wasn't a submission.
So I adopt that as my submission.
I gave up making submissions a long time ago, Mr. Berry.
Well,
I adopt that as a submission.
But we are stuck with Lord Justice Longmore's
We are.
dictum in perhaps more than dictum in Wuhan, that in this area, businessmen are entitled to more guidance than simply looking at the language, and the point is in both directions, and that there ought to be some presumptions they can work on.
And if that be right, my submission on that, just so I don't have to come back to it later on, but if that be right, then my submission is that the presumption should be that where an instrument contains the 4 features identified in paragraph 25 of my skeleton, which I've identified, that is to say, primary, unconditional, not as surety, payment on demand, not affected by any dispute, and a proviso to pay against the document. Those 4 items mean, in the Master of the Rolls formulation, or ought to be presumed to indicate, in the Wuhan formulation, a demand guarantee. So insofar as one wants to lay on top the general principles of construction, I submit that those 4, put together, that 4 sets of language mean a demand guarantee, or it's presumed to mean a demand guarantee. Of course, one can never say always, because there may be another clause saying, by the way, this is not a demand guarantee, this is a contract of suretyship. But subject to that, those words without explicit contradiction mean a demand guarantee, or in Lord Justice Longmore's approach, ought to be presumed to be there. Can I go to, because of that, go to Lord Justice Longmore, just because what I submit about Lord Justice Longmore is that in his case, in effect, he did say what the Master of the Rolls indicated. He did say that there's particular wording here which does mean a demand guarantee, and it's strikingly similar to our wording. And if I can just put it this way, in my submission, the wording in Wuhan is identical to our guarantee, save only that it does not have the proviso to Article 4, so subclause 4, the arbitral proviso. And as Lord Justice Popplewell has indicated, he did say, so this is Authorities Bundle, tab 7, starting at page 143.
Which paragraph?
Paragraph, I'm going to start at 26. But if I may just say that at 23 and at 24, he identifies the factors for and against. And I would simply point out that the factors for demand guarantee in paragraph 24 include the factors that we rely on, except for the proviso, and in particular the word immediately, which is in the 4th line of paragraph 24. And in paragraph 25 is the paragraph my Lord Popplewell adverted to. In deciding whether the document is traditional see-to-it guarantee or on demand, it would obviously be absurd to say that there are 6 in favour of the former and only 4 in favour of the latter, and therefore it must be the former. But if the law does not permit boxes to be ticked in this way, commercial men will need some assistance from the courts in determining their obligations. The only assistance which the courts can give in practice is to say that while everything must in the end depend on the words actually used by the parties, which I commend, there's nevertheless a presumption that if certain elements are present in the document will be construed in one way or another. Now, in my submission, what this judgment actually means, although he doesn't say it to that point, is that if you have those 4 elements in paragraph 24, which we do in this case, and one more, it's a guarantee. And if he then quotes Paget, and that's what I refer to right at the beginning of paragraph 26, under the heading Contract of Suretyship versus Demand Guarantee. And then he sets out the Paget presumption, which is, in my submission, only a starting point. But the Paget presumption is one going the other way, in favour of demand guarantee. And the paragraph 1, different jurisdictions, tick, issued by a bank, cross, but with the caveat that, yes, but it's a financier rather than a parent or a shareholder, contains an undertaking to pay on demand, tick, and does not contain the clauses excluding or limiting the defences available to guarantor, cross, which was also the case in that case. It did contain those. And in construing guarantees, it must be remembered that the demand guarantee can hardly avoid making reference to the obligation whose performance guarantees security, a bare promise to pay on demand without reference to the principal's obligation would leave the principal even more exposed. And that is why it is neutral to say in the event of non-payment under the contract, because you've just got to say that as the thing that has to be demanded. And then there's a presumption. Perhaps we can go over to page 1199 of the report, 151 of the bundle, para 29. Or 28. Paget's presumption was in due course approved by this court in Gold Coast against Caja de Arose, where my Lord Popplewell succeeded, where, as counsel, where the document was held to be an on-demand guarantee, although, as in this case, the fourth element of the presumption was absent, but the others were present. The fact is that guarantees of the kind before the court, in this case, are almost worthless if the bank can resist payment on the basis that the foreign buyer is disputing whether payment is due. This would be all the more so in a certificate case. And then he, in effect, by then has come to the conclusion that it's a demand guarantee. And at paragraph 30, he says, why then did Mr. Justice Christopher Clark come to the contrary conclusion? And he runs through all those elements, all of which are reflected in my learned friend's submissions here, except for the point about the second proviso. And he says at 31, there would all be serious points if the court was approaching the document on a wholly fresh basis without regard to previous authority. And we look at some of that, but Caja de Arose was possibly one that he had in mind there. And granted the positive factors, there were positive factors, and granted those positive factors and the presumption in Paget in the same wording, I interject to say, albeit in that case only 3 of the 4 ticks, in our case 2 of the 4. Supported by previous authority, the judge ought, in my respectful view, to have much more regard to the presumption than he did. And Mr. Justice Hurst says that there should be a consistency of approach. And then 32, there are moreover indications that the document, which began as Exhibit B, was to some extent drawn up by persons not entirely familiar with the English language. It may be something of a palimpsest, to use the words of Lord Diplock, incorporating words of previous forms. Not in my judgment right to treat the words with similar reverence to the reverence which one would constitute a statute. It is much better and indeed simpler to be guided by the general tenor of previous authority, enunciated by past judges of great distinction. I don't think that's an invitation to inquire into the distinction of particular judges. But I do submit that that principle applies to this authority itself. And if we can look at the guarantee, if we may, itself, bearing in mind, and that is at page 146 of the bundle within
paragraph. What did the judge say about Wuhan?
Sorry?
What did the judge say about Wuhan?
The judge said that...
I'm just checking for myself.
It's at 13 and...
13 is the argument.
Yeah. 31, yes.
61.
Yes.
Yeah.
Right.
He said it's distinguishable because it was a bank.
It was a bank, and it was a bank in that case, yeah.
And he also, I think, at paragraph 28, he said the previous authority was not necessarily helpful in paragraph 22, but in the later paragraph he said, however, one should follow the general tenor of them. And the instrument in Wuhan did not have all the language of clause 4 discussed above. And that is a reference to the proviso. Yeah. And so if one is trying to create the ratio of the judge's distinction of Wuhan, it is 1, not bank, 2, no proviso. As I say in my submission on that is that it would be most inconvenient if materially identical wording meant different things, radically different things, when issued by a funding investment company, as in this case, as when issued by a bank, which may also be funding, as we'll see. In some cases they do fund and aren't merely issuing documents for fees. And secondly,
I stopped you. You were going to go to the terms of the guarantee in Wuhan.
I was going to say that the proviso is a point the other way. The judge misunderstood
Yeah,
that.
no, I know you say that.
Page 146, paragraph 15. And it might be well to have in mind our document. Well, I won't compare paragraph by paragraph, but my submission is materially identical. The only difference is no proviso to paragraph 4. So in paragraph 1 at page 146, letter H, hereby irrevocably, absolutely, and unconditionally guarantee. They even use the same capitalizations as primary obligor and not merely as the surety, the due and punctual payment. And then 2 is materially the same as ours. 3 over the page at 147, 1195 of the report is materially the same as the interest clause. And then 4, in the event that the buyer fails punctually to pay the second instalment guaranteed annually, or the buyer fails to pay an interest and such default continues with a period of 20 days, well, that's, somebody has gone through this and changed ours to 15, but that's 20. Okay. Upon receipt by us of your first written demand stating that the buyer has been in default for 20 days, we shall immediately pay to you or your assignee the unpaid second instalment, together with the interest and so on. And then I observe no proviso. So in our contract, the proviso has been added after that in paragraph 4, and then otherwise
The two clause 5s are the same to all
Yes.
intents and purposes.
and the clause 7s are the same to all,
Yeah.
exactly the same to all intents and purposes.
And the proviso, it doesn't have a separate number. It's just been tagged onto
Yes.
4.
Yes, it's just, one can see how this happens in word processing terms. Somebody said, "Oh, why don't we have a proviso?" And so I call it 4 proviso, but you could call it 4B or something. Yeah. So that's so this instrument is materially identical, indistinguishable except for the proviso, and the fact that it was a bank, and it would not give. Well, I suppose it would give some guidance, but it would be very odd if the identity of the grantor were to make that level of difference. Now, that's Wuhan, and you have my submission about the proviso. But I would say about the proviso that there are 4 cases with provisos in similar form. I can't remember if anything's exactly identical, but no, I think they're all similar form. There are 4 cases that have been found by the parties where there have been provisos, and each one of them has been decided to be a demand guarantee. And can I take you to one of those? Then that's split-offs, and that's in tab 8, page 153 of the bundle. So I should say my learned friends place some reliance on the judgment of Mr. Justice Christopher Clark below in Wuhan, but as he was overruled, I'll wait to see where that takes them. So yes, split-offs. Perhaps I can start with the guarantee in split-offs. It's page 160 of the bundle, 1041 of the report, quoted in paragraph 21. I apologise. And in the last paragraph on that page, we, Bank of China, so it's a bank, as primary obligor and not as surety. It says security, but in my submission that's clearly non-native speakers mistake for surety. Do hereby irrevocably, unconditionally, absolutely guarantee payment with a limit representing the first 3 instalments. And so this is a repayment guarantee, which is the flip side type of guarantee. And then at the top of page 4, sorry, at the top of page 161, 3 lines down, we have the equivalent of, in my submission, our clause 4. Should the seller fail to make such repayment, we shall pay you the amount the seller ought to pay with interest, so on and so on and so forth. And then against the letter B, within 30 days of our receipt of the relevant written demand from you for repayment, such demand being authenticated may be made in writing, and then there are provisions that our provision for that was later. And then you have clause 7, the equivalent of clause 7 in our case. So the order is different from our case, but our obligations under this guarantee shall not be affected or prejudiced by any dispute and those other things, and that is materially identical to our clause 7. And then you have the proviso post-dating clause 7. However, in the event of any dispute between you and the seller in relation to those two things, and such dispute is submitted either by the seller or by you for arbitration or appeal in accordance with Article 13, we shall be entitled to withhold or defer payment, and so on. So that's materially, in my submission, the same. And Her Ladyship decides the case that this is a demand guarantee, and she in particular rejects the submission that the proviso is to the contrary effect. And really that's at paragraphs 72 and following to 85, at page 170 to 172. I won't read those out, but may I just identify particular points that we rely on more than the general tenor of this. Paragraph 75 at the bottom of page 170 of the bundle and 1051 of the report. The Bank of China suggests that the third on-demand factor is not present because of the proviso, and by that she means the arbitration proviso. The obligation under the second paragraph of the guarantee, and that is the equivalent of our clause 4, is to pay within 30 days of authenticated demand. It's unequivocal. The proviso engages only in limited circumstances, falls to be considered separately. The guarantees make it clear that any disputes between SPV and the sellers are irrelevant to BOC's obligation to pay. Now pause there. In my submission, that is a reference to clause 7 of ours and clause, the one at page 1042C in this guarantee. And that is, in my submission, a killer point. If the guarantee says disputes are irrelevant, save in one exceptional circumstance, there it is. The obligation is primary obligation, obligor, not security. Well, in my submission, that must mean surety. And irrevocable, unconditional, absolute. The fact that the obligations engage should the seller fail to make repayment, in our case, in the event that does not point to the imposition of a secondary liability, but rather to the circumstance in which the obligation on BOC is triggered. Equally, the fact that the sums mirror the sums due doesn't point to a secondary liability. Whether or not the third on-demand factor is present, BOC relies heavily on the proviso, particularly by reference to paragraph 29 of Wuhan, and in Wuhan, counsel, at first instance, counsel for the claimant expressly relied on the absence of a provision deferring disputes as indicative that there was a performance bond. In my judgment, neither the proviso nor the fact that the guarantees contain clauses limiting defences available to a guarantor justify or tip the balance in favour of treating the guarantees as contracts of surety. As for the proviso, the event of a qualifying reference, BOC's liability is nevertheless still triggered by a document, namely an award or court order, not by reference to the merits of any underlying dispute, and so on. BOC is not required to become concerned with the merits of the underlying dispute. The question is timing, not substance. And so, in my submission, that is an articulation of the reasoning why the proviso on preliminary issue 1 points demand guarantee, and is a point in my favour. And the combination, if I can extract the ratio from this part of Her Ladyship's decision, it is the combination of clause 7a in ours, guarantees make it clear that disputes are irrelevant to the obligation to pay, and the fact that the proviso, firstly, does not take that away, but secondly, creates another obligation, or obligation in certain circumstances to pay against the document, are powerful, if not conclusive, on the first point. And then at 79, she identifies merits and tankship, both of which had provisos, and both of which were treated as demand guarantees and not contracts of surety, and quotes from 116 of Mr. Justice Blair in tankship. The bank's argument on the proviso is that the reference to an arbitration award is an indication that liability is secondary. This provision does not, in my view, imply in any way that the guarantor's liability is secondary. The instrument is conditioned either upon the certification in the demand, or if the dispute goes to arbitration, the amount of the award. Essentially the same argument on very similar positions was rejected in merits. So in my submission, there's a line of three cases, merits, tankship, and our case, which say, in effect, in my submission, that not only is the proviso not an indicator of suretyship, it's an indicator the other way. And the rest of this is of some importance, but not, those are the particular passages I identify. Now, there is a point in my learned friend's, moving to preliminary issue 2, there is a point in my learned friend's submission, skeleton at paragraph 60, which said that Splithoff is authority for the proposition that, at least in that arbitral proviso, a post-demand arbitration, or rather a post-obligation arbitration, would suffice to suspend. Now, in this respect, there is a bit of a difference between this proviso, this demand and ours, in that in our demand, it's the 15 days runs from the demand on the builder, but the obligation is to pay immediately on demand of the guarantor, whereas in this guarantee,
Which is this? We're talking
the Splithoff guarantee.
Splithoff.
So in ours, it's 15 days delay in paying by the builder plus demand immediately pay. In this one, it is 30 days after the demand on the guarantor. So I don't know if that I don't know if that doesn't make any difference in principle in my submission to the nature of the instrument, but it might impact on issue number 2. But my learned friends at paragraph 60 rely on paragraphs 149 to 151 at page 184 of the bundle or 1065 of the report to say that, Mrs. Justice Carr accepted that a post-demand arbitration would trigger the proviso. And my submission is, firstly, no, she didn't. And secondly, but if she did, that could only be because there was that 30-day period before the payment obligation accrued. And therefore, there was no accrued right until the 30 days had passed. But, and finally, I say, it certainly wasn't a point that she was deciding as a matter of ratio, and she was considering it in a context of validity of demands. But let's look at para 149 at page 184, and bear in mind the dates. There was an old arbitration reference called reference Hull 39 reference number 1, which was resolved and concluded by an award published on the 9th of February. And by the way, that just shows an example of what I have submitted is well known in shipbuilding contracts, which is arbitrations during the course, the running of the thing, before delivery. Thereafter, in the absence of any fresh dispute being raised by sellers in relation to SBV's subsequent cancellation of Hull 39 contract on 15th February, and their resulting obligation to refund, there was no dispute. The purpose of the proviso, which accordingly was not engaged. The proviso was in effect an irrelevance at the time of the demand. No award was required. So we have solving of the earlier dispute on the 9th of February, cancellation of the contract on 15th February, which creates results in the obligation to refund, and at that time no dispute, at the time of demand. And then she says, BOC submits that this approach ignores the wording of the provisor. Once a dispute falling with the provisor is referred to arbitration, BOC waits for an award and obligated to make payment. In my judgment, that's not a fair or correct construction of the provisor or the terms of the guarantee as a whole. Reference to arbitration suspends the timing for BOC's obligation to pay during the currency of the dispute, but does not prevent an obligation to pay irrespective and independently of any award arising on the part of BOC subsequently. Here, after cancellation of the Hull 39 contract, and that was 15th of February, remember, and in the absence of any dispute then being referred, i.e. upon, in my submission, cancellation, to arbitration under the proviso, the terms of the proviso were not in play, and I submit that means not in play on the date of the demand. So, even on the terms of that guarantee, it doesn't, and she certainly wasn't considering the point, it's a throwaway at best. And so this is not of assistance to my learned friend. If anything, is of assistance to my client on the timing of the requisite dispute and arbitration under preliminary issue 2.
I'm slightly puzzled here. This seems to be advanced on the premise that there was no dispute on the 23rd of May 2017 when the demand was made. Is that the position that's being advanced? Because that is news to me.
No dispute and no arbitration?
No arbitration, certainly, but there certainly was a dispute, wasn't there? Because, I mean, the contract had been terminated for a start on the grounds of non-payment. So, I just want it to be, there's the reference to arbitration. The point that's being taken against me, as I understand, is even though there was a dispute, it wasn't referred to arbitration before the demand. If it's now being said that there wasn't actually a dispute, that's a factual point that's never, ever been suggested.
Well, there was a dispute in the sense that there wasn't payment and there was cancellation, but there's no evidence of a dispute on the particular issue, and there's evidence against a dispute on the particular issue that needs to be disputed.
No, this is not a point that's open to my learned friend. This case has proceeded from day one on the basis that there was a dispute, but that it hasn't been referred to arbitration by the 23rd of May 2017. If a different case, well, it's simply not open to my learned friend to advance a different case if that's what he's attempting to do.
Right, well, let's come to that in due course and let Mr. Berry say what his position is, and you can say it's not open to him when you get to it.
Well, there may be a technical answer to this, which I suppose is that preliminary issue 2 refers only to arbitration,
Yes.
and not dispute,
Right.
Which would mean that in the event that there was no dispute, there would be an amendment, and then because this is only a preliminary issue, and then one would come back on that. But my submission is that there's certainly no evidence of a dispute on the particular point which has to be disputed, and there's evidence of not dispute at the time. But that might go beyond the preliminary issue and therefore fall for another day. However, whether relating to dispute or demand, the point about 149 to 151 is that there was no arbitration. Because if one looks at the last two lines of para 151, here, after cancellation of the Hull 39 contract, and in the absence of any dispute, so she's neutral whether there's any dispute, then being referred to arbitration. The terms of the proviso were not in play. In my submission, far from a concept that, far from endorsing a proposition that a later arbitration works, she is saying that what matters is the date of the demand, because a dispute had not then been referred to arbitration. Can I quickly show? WS tank ship. I won't show the merits is relied on in Splithoff, and the WS tank ship is at tab 6 of the bundle, and the guarantee there is at page 105 to 106 of the bundle and paragraph 54, and I will simply submit that it is materially similar to our guarantee. If at page 106 one sees the penultimate paragraph, that is numbered by the judge elsewhere, Mr. Justice Blair, as paragraph 6. So the paragraph that starts notwithstanding the provisions herein above, that's paragraph 6 of the guarantee, and that is an arbitral provision in slightly different terms, disputed and referred to in accordance with the provisions of the contract. Now, in my submission, the finding in this case was that this was a demand guarantee, and on preliminary issue 1, I rely on this on that point. So far as preliminary issue 2 is concerned, that may require a closer look at the wording, but the point for present purposes is that, well, perhaps I can go to paragraph 112 at page 122, just for the particular propositions amongst the more general ones which are still relevant. At paragraph 112, several lines from the bottom, he's talking about the fourth proposition, which is exclusions of guarantor defences, and he shows that the fourth factor may be neutral, and then demand is not determinative, and so on. I don't think that helps all that much. It's para 116 at page 123. That's just mere reinforcement of the general submissions. So page 123, paragraph 116, Kwangju Bank's argument on the 6th paragraph of the guarantee, point 4, and one sees that in the text of paragraph 113, so it's point 4 within 113. It's to the effect that the reference to the arbitration award is an indication that liability is secondary, and he rejects that argument, as did Mrs. Justice Carr in Splithoff and the court in Merits. But just for present purposes, to note, in the middle he says, just below the middle of the paragraph, it is true to say that there may be an issue on the construction of the guarantee where there has been a prior demand under the 4th paragraph, but that does not arise in this case where there was no reference to arbitration. And that is the nearest I submit of any consideration of any question whether the arbitration has to be before or after demand. So the point in my submission is fresh for your lordships without the benefit or burden of previous authority. So I show you that because as far as my research has gone, that's the nearest adversion to that particular issue. Can I just show Rubicon? And that is in tab 12, page 266. And the guarantee there is at page 269 of the bundle and 386 of the report. And without reading, if I can summarize, it has, albeit in somewhat different wording, all the features of the guarantee in our case, which point towards demand guarantee. And then at paragraph 5 of the guarantee, over the page at 270, I think it's still part of paragraph 11 of the judgment, but anyway, it's 270 or 387 of the report, just above the middle of the left-hand column. Actually, we'll perhaps start at paragraph 4. In circumstances where the amounts demanded under this guarantee are not in dispute, the guarantor shall be obliged to pay the amounts demanded within 48 hours. In the event of disputes between the company and the contractor as to the company's liability, in respect of any amounts demanded under this guarantee, the guarantor shall be obliged to pay any amounts demanded up to a maximum of 3 million, and the guarantor shall be entitled to withhold and defer payment of the balance of the sum demanded in excess of 3 million until a final judgment. And his lordship at page 271 of the bundle 388 of the report, then points out that this guarantee is slightly unusual in that it comes within both, or certainly parts of it come within both of the presumptions going the opposite ways. So at paragraph 14, he talks about the Marubeni presumption. At paragraph 15, he talks about the Wuhan/Paget presumption. And then he says, perhaps rather unusually, the guarantee in this case falls into both categories. Parent company guarantee, but in fact, parent company. But, he says lower down, the parties also agree that there are some circumstances in which Chris can be liable to pay in response to a compliant demand, even if there is an unresolved dispute. And he's referring there to the 3 million obligation. Unresolved dispute, they have to pay 3 million, and they only pay the remainder on a final judgment or final non-appealable award. And what he then says in paragraph 18 is that when that is the case, the Marubeni presumption, i.e. the non-banking presumption, is spent because at least part of this document pays on demand despite dispute. And then he says the only question is, as a matter of construction, when it does so. And in my submission, that reasoning is valuable in that it supports my submission that where an instrument at least sometimes pays on demand, irrespective of true underlying liability, then it's a demand guarantee, and the question, of course, is when? What are the circumstances in which it pays? That's what his lordship identified, and he, for that purpose, characterised the document as a demand bond in the sense that the beneficiary did not have to prove an actual liability for the demand that was made up to 3 million. Of course, that 3 million, pay 3 million even if there's a dispute, is different in particular to our demand, to our guarantee, but not in my submission different in substance, because clause 7A of our guarantee says disputes do not affect obligations, and that is a complete clause saying the obligation to pay, the obligation under the guarantee is not affected by dispute. This is half as good as clause 7, in the sense that it says 3 million is payable despite dispute. Our clause 7A is a fortiori in that it says always pay without dispute, with the caveat of the text of the arbitration. So this is another, and this is a non-bank, this is Chris Energy, who is a true parent, and in my submission, it is authority that the nature of the guarantor is, if anything, of very light weight. It's authority that an arbitration proviso, both of this sort and of our sort, indicates a demand guarantee, and the simple question is construing what has to be provided. Now, there are a number of cases where, on the question of the identity of the guarantor, there are a number of cases where the guarantor was not a bank. Nevertheless, it was held to be a demand bond because of the wording, even though described as a guarantee at the head. And perhaps I can just take these by reference to my learned friend's skeleton at 46, I think. Yes, 46. And the at 46, the way they put it is that the presumption is rebutted. I would say yes, the presumption is rebutted, but I would also submit, subject to Popplewell's point, that the presumption doesn't arise because there is language in the instrument describing it as a bond. And so here I am, my submission here is that if there's anything in the Marubeni presumption, it is easily rebutted or does not arise because of wording such as what we've got here. And at the top of page 42 of the core bundle, my learner friends, paragraph 46.1. Van der Merwe, it's true that there was a certificate clause there, see paragraph 32, but if I can just make a submission on it, if one looks at 31 and 32, it was primarily the language of not as surety and on demand that led to that one being a demand guarantee. Bitumen, the court described the transaction as essentially a financing arrangement, and the obligation was to pay on demand as certified. In my submission, this is essentially a financing arrangement, so that's not a ground of distinction. And the obligation is to pay on demand, well, in my case, as demanded, and the word certificate doesn't add much to the requirement of the demand. Ultra bulk, no, that's ultra bulk, not ultra bank. I'm afraid that's a mistake common to both parties, paragraph 46.3. And the ultra bulk case is in tab 11. The surety was not legally represented, true, but the counsel appearing for the beneficiary drew the judge's attention to the relevant principles under Marubeni by reference to Autoridad, and it did also contain a promise not to contest or defend, but essentially that is a case where demand and primary obligation wording contributed at least to the rebuttal of the presumption, and then multiplex, in which there was no consideration of the Marubeni presumption. Can I, and I should say, Rubicon is also a case of a demand bond issued by a non-bank, but I've shown you that one. But can I just pick up the submission in 46.4 about Marubeni? Multiplex. That is at 10, section 10 of the authorities bundle. And if we look at page 258 and paragraph 40, 258 of the bundle, 47 of the raw, paragraph 40, the judge did set out through the medium of Vossloh what is in effect the Marubeni principle, or part of the Marubeni principle. It's quite clear that he was treated to Marubeni, and indeed that's evident also from the list of cases at page 248. So it's might be true to say there was no specific discussion of the Marubeni principle, but the judge was aware of it. And another case where Mr. Dunn, who was an interested shareholder, not a bank, in one of the companies, gave a guarantee. The guarantee is at page 253 of the bundle, 42 of the report, and it's has similar features, but has dissimilar features as well. But for present purposes, can I invite your lordships to note paragraph 42 of the judgment, page 259 of the bundle and 48 of the report, where he is considering whether he's considering its nature as a demand bond or a surety share. And he says at this point it's the commercial context and the words themselves, which I don't rely on the commercial context, but I do rely on the words themselves, make it clear what the nature of the obligation is. So he goes to words. Mr. Dunn irrevocably and unconditionally guarantees, warrants, and undertakes jointly and severally to multiplex that in the event of insolvency, he would be immediately liable to the contractor for the payment of the advance payment. In my judgment, the use of the word immediately is very important, if not crucial. It simply would not be possible to repay the advance payment immediately. Any sort of accounting had to be done. And so on the first issue, I make that same submission about the immediately in our document. The immediately in our document is a feature that makes our guarantee even more strongly a demand guarantee than, for example, the one in Splithofs, where there was 30 days. So that's what that's my submission on those cases. What they show is that if the wording, and I'm referring to the cases in paragraph 46 of my learned friend's submission plus Rubicon, if the wording indicates demand guarantee, and particularly if it includes those features of wording in paragraph 25 of my skeleton, then that prevents the Marubeni presumption arising or rebuts it. And in these days where parents of financiers or funders or investors and banks also sometimes lend, that bright line presumption is not strong but rebutted. My learned friend refers to two cases, the Voslo case and the Autoridad case, but the guarantees there were materially different because the judges there found explicit wording to the effect that the guarantor would only pay if the liability was properly due in the underlying contract. So if it's they're relied on, I might reply to that. That's Voslo is A3, and the paragraphs to look at are 15, 41, and 53. And Autoridad is A9, and the paragraphs to look at are 92 and 93 there. I should also add that Autoridad summarizes the principles in a way that is not objectionable, but emphasizes that while there might be indicators going one way or another, it is ultimately a matter for the wording used. And my submission is overtaken by Wuhan and Splithoffs. So that gets us back to preliminary issue 2. But I think I've made my submissions on that already. It's accrued rights not to be taken away without clearer wording than this, particularly when it is permitting one party to take advantage of its own breach. And whilst I threaten to go back to the wording, I think I've made all my submissions on the wording in the course of that. So the iterative process of going back to the wording doesn't mean going back and repeating yourself. So those are my submissions.
Yeah, thank you very much, Mr. Berry. Mr. Sullivan.
My Lords, in relation to issue 1, the nature of the guarantor's liability, we say the judge was right to hold that on its true construction, this guarantee imposes a purely secondary liability on Reignwood as guarantor, by which I mean its liability is conditional upon the buyer being shown to be in default of its obligation to pay the final instalment under the shipbuilding contract. I will show that the cases relied upon by my learned friend as pointing to primary liability should be distinguished from the present case, either because they are banking cases and this is not, or because the wording of the guarantees was very different. And in relation to issue 2, I say that all that is required for the clause 4 proviso to apply is the existence of a dispute as to whether the buyer is liable to pay the final instalment to the yard, which is then referred to arbitration, and that the timing of the reference to arbitration is irrelevant. In relation to issue 1, what I'd like to do is look at some of the principles laid down by the cases before turning to the wording of the guarantee itself, although obviously it's common ground that you have to answer the questions raised by reference to the actual words used by the parties. I say the starting point for construction is that this is not a banking instrument, and Reignwood is therefore entitled to take advantage of the Marubeni presumption. I say that with some caution, having heard the Master of the Rolls' comments. And the Paget presumption does not apply.
Well, I seem to be out of touch with the presumptions in this area, so maybe I'd best shut up.
But your Lordship is in the fortunate position of being able to perhaps express views that I am not able to do. But I say we can take advantage of Marubeni and Paget doesn't apply. And I will ask the court to follow the approach of Sir William Blackburn in Voslo and Other Trains, which is a parent company guarantee case, and preference to that of Mrs. Justice Carr, as she then was, in Splithoffs and Bank of China, which is a banking case. So performance bonds are essentially banking instruments which are treated by the courts as very similar to letters of They require the bank to pay against documents on demand. The bank has no concern with any underlying contractual dispute between the buyer and seller. Therefore, the commercial advantage of certainty of cash flow to the beneficiary and are said to be equivalent to cash in hand. But they do come at a price. The bank requires to be paid a fee for the risk which it takes in making payment against documents. And you will therefore expect to see express provision in the instrument for the bank to be made whole by its client in the event that it's required to make a payment. The purpose of the parent company guarantee is different. The commercial value of such a guarantee is not cash flow, but that the creditor has security for payments due from the debtor, which may not be of sufficient substance to be able to afford the payments. The parent company stands behind the subsidiary and gives comfort to the creditor. The parent does not enter into the guarantee because it's its business to earn fees from issuing such instruments, or because it's going to be paid a fee by its subsidiary. It does so because it has a commercial interest in common with the subsidiary, and because a third party may be unwilling to contract unless the parent stands behind the subsidiary. And for these reasons, the dicta of the courts in banking instrument cases do not apply outside the banking context. And we see that from Marabini itself. If we could look at tab 1, physically, I believe it's page 10 of the PDF. Because scrolling down from paragraph 22 onwards, Lord Justice Carnwath begins with a discussion of the authorities, and in particular from paragraphs 21 onwards, he considers the section in Andrews and Millett on performance bonds or demand bonds, and he refers to Jack and a number of the well-known cases. For example, one sees the reference to Edward Owen Engineering and Barclays Bank, paragraph 22. And at paragraph 23, one scrolls down, this is page 11, he sets it in context. These passages provide the context for discussing the cases relied upon by Mr. Howard. They show that demand bonds, however described, are a specialised form of irrevocable instrument developed by the banking world for its commercial customers. They have been accepted by the courts as the equivalent of irrevocable letters of credit. As such, they have been described as part of the lifeblood of commerce. And if I could ask you to scroll down to paragraph 25, he quotes there, again from a well-known case in this context, Siparex Trade and Bank Andrew Suez, where the judge says, "There is in my judgment no real hardship on the bank in imposing this strict liability to pay. A performance bond is a commercial instrument. No bank is obliged to enter into it unless they wish to, and no doubt when they do so, they properly exact commercial terms and protect themselves by suitable cross-indemnities, such as were entered into in the present case." And we also rely on paragraph 28, which is on page 13. In a similar vein, the judge continued, "In all these cases, the documents were issued by banks and were described as, or assumed to be, performance bonds. Not surprisingly, the courts interpreted them against the background of the law relating to such instruments. They provide no useful analogy for interpreting a document which was not issued by a bank and which contains no overt indication of an intention to create a performance bond or anything analogous to it." Paragraph 30, lower down on page 13, Lord Justice Carnwath lays down the presumption which we rely upon. He says the starting point, in my view, is that it is not a banking instrument and is not described either on its face or in the supporting legal opinion letter in terms appropriate to a demand bond or something having legal effect. And then he points out the terminology. What he's saying there in my submission is he's saying that the label the parties apply is not definitive. And in fact, we see that from many of the cases. And he then goes on to paragraph 31, where he suggests that having started from the point that it's not a demand bond, the question is whether there are sufficient indications in the wording of the instrument to displace that presumption. And he says Mr. Howard relied upon the words unconditionally pledges and simple demand, but they are qualified by the following words, which indicate that the obligation only arises if the amounts payable under the agreement are not paid when the same becomes due. As Mr. Justice Cresswell said, this is wording appropriate to a secondary obligation, that is, one conditional upon default by the buyer. So that's Marabini. Now, I accept that in the merits case, the Court of Appeal extended the Paget principle to insurers.
Just before
Sorry,
we go to
yes.
that, does this submission mean that a document which is in identical form can, in the one case, if issued by a bank, be construed as an on-demand bond, but in another case, if in identical terms, but issued by a parent company, be construed as a see-to-it guarantee?
Yes, my lord. I don't shrink from that, making that submission. In fact, every case is different. There is no case in which the wording is identical. But yes, even if it were precisely identical, I would go that far. And that is precisely what the Marubeni line of cases shows. And in fact, I'm going to show you, when you get to Vossloh and you compare it with Splithoff's, you'll see that the judges look at very, very similar wording and come to diametrically opposite conclusions because they start from different starting points. In Vossloh, Sir William Blackburn starts on the premise that it's not a banking instrument and not a demand guarantee. And Mrs. Justice Carr and Splithoff starts on the basis that it is. And they actually come to different conclusions on very similar words. So we're already in that territory, my lord.
Well, how does that create commercial certainty
Well,
for international businessmen?
well, I can see that it's not ideal, but nonetheless, the Marubeni presumption creates great clarity in my submission.
Why shouldn't you start from the words?
Well, this is the point that the Master of Rolls has already made. I mean, obviously, at the end of the day, one is starting from the words. But...
At the end of the day, one's starting from the words.
and at the end of the day, one's starting from the words. No, absolutely.
And at the beginning of the day,
Yes.
one might say.
Of course.
Yes.
But I think, for example, I mean, the thing is, if one looks at words, I mean, if you look at the words of clause 1 of this guarantee, we will come to the wording of it. You might look at it and think, oh, well, isn't that obviously, it refers to primary obligor as a primary obligor, not a surety. Isn't that obvious? Well, the answer is when you look at all the weight of case law, you'll find, in fact, there are many cases where those words have held not to be definitive at all. First demand, immediate demand, again, not definitive, it all depends.
Well, come back to my Lord Master Rose's point. How is this helping international businessmen?
Well,
I mean, what could be clearer than words in capital letters, irrevocably, etc.?
well,
Red hands and flashing lights. What more?
well, indeed. I mean, it's a pity that the drafts people of these instruments don't pay attention to what the courts say. But, and the fact is, I'm going to show your lordships after the short adjournment that those words in Vossloh and in the Panama Canal case appeared in instruments which were held to be secondary, to give rise to secondary liability. They're not definitive when you look at the whole instrument.
So what's the draftsman supposed to do? I mean, if simply using the words of a demand bond are not sufficient, what do they have to do? Do they have to have the flashing lights?
Well, you could do, for example, what was done in Rubicon. I mean, I'm going to come to all these cases in due course, but Rubicon, for example, they make it very clear. They say even if there's a dispute as to the sums demanded under the guarantee, you've got to pay up to $3 million, and after that you can defer and we can have an argument and it can go to arbitration. So, and that was so clear that it was actually conceded by the guarantor that imposed primary
But that's a
liability.
different situation. I mean, I'm talking about a normal situation where that's not an agreed provision. And, I mean, do you really go so far as to say that there has to be a big red stamp on the outside of the document saying this is a demand bond, this is equivalent to a performance bond, it doesn't matter, we're not a bank, this is what is intended by the parties. All these authorities are not relevant to us.
Well, that would certainly help if you were the draftsman. But I mean, when I come to this guarantee, I will show that in fact the language is redolent of the language of secondary liability. So it talks about if the buyer does not pay, we shall pay. It refers to default. It refers to interest running from default. It says we shall not pay you in the event of a dispute unless the award orders the buyer to pay the final instalment. So
the language is the Wuhan language in essence, with other things dropped into it.
So, well, yes.
One thing.
And it's not a bank.
Well, possibly more than one thing, but one important thing.
Yes, I mean this is very similar to Wuhan, except that this is not a bank, and there's the proviso. The proviso makes all the difference in my submission, because it shows that there are circumstances. If there's a dispute under the underlying contract, there is no liability.
The proviso makes all the difference. So
The proviso makes all the difference.
Why are you stressing the fact that it's not a bank?
Well, both of them.
We're going back
I mean,
to wording.
I'm
Ultimately,
not-
it comes back
I
to
have 2
wording.
points. I mean, that's how I opened my case to Mr Justice Knowles, was that there are 2 critical points of difference from Wuhan. One, that this is an instrument not issued by a bank. And I accept that the conclusion, it leads you in extreme case to the conclusion that in theory, 2 similarly worded instruments could give rise to different consequences.
Well, it may not be theoretical. The CMAC form, the Shanghai form, provides that, for example, refund guarantees are to be given in the given form by a first-class bank.
Yep.
Now, if the beneficiary is happy to take a guarantee in that form from a parent rather than a bank, it would be pretty odd, wouldn't it, to construe it as meaning something different.
Well, I mean, that's...
And there are parents and parents. Parents may have different qualities. The parent may be of such substance that the beneficiary thinks they're equivalent to a first-class bank in terms of financial probity and solvency.
Yeah, but I mean, I haven't come to the end of my submissions on the difference, but because we shall see, because one of the differences is that the bank, this is the bank's business to issue these bonds. It's not the parent company's business. It's got a completely different stake in the affairs of its subsidiary. And if the parties want to bank a performance bond, they jolly well will have to pay for one from a bank. It might cost them more. I mean, it may well be that they go for the cheap option. It's cheaper to get a parent company guarantee because you haven't got to pay a bank to take the risk. You haven't got to pay a fee. So on your head be it, if that's what you choose. I mean, your secure way in that situation, if you want to benefit from a guarantee, is to make sure it's issued by a first-class bank. And if your judgment were to indicate that there was a critical decision, the difference, then that would afford real clarity to the people in the market. They would know what they had to do. Because, as you can see, it's the banking cases where they're held to be demand guarantees and where they're parent company guarantees, the balance is the other way.
Right. Well, shall we...
Is that a good moment?
Yes. Shall we come back at 2 o'clock?
Yes, thank you.